So I'm a long-time professional victim advocate and the executive director at Mothers Against Murder, a nonprofit humanitarian agency in the San Francisco Bay Area and the city of Los Altos. I was physically present along with MAM's college intern at the first public hearing about 2 weeks ago on December 12th. And then I wish again to give suggestions and disagreements for the second time to be included in the public records. Specifically on the proposed amendment of 649.4, eligibility of felons. My agency, MAM, mostly deals with helping families of murdered victims. So the section where it says compensation to an applicant for any expenses incurred to a victim's death will not be allowed when the victim is incarcerated or in a correctional institution. We disagree with this language, and I've given this a lot of thought, and I have experience with this some 20 years ago. The same issue was raised, and the same reasons that I have now, I had discussed with the chief counsel of CA VCB, and it was accepted, and the program started paying for funeral and burials of a victim who died in prison, because the expenses incur after the body is released to the family. So it is no longer in a correctional institution, which fits the statute of allowing such claims. And also the law, Government Code Section 13956C1, would allow expenses for convicted felons who are no longer on parole or probation. And death abates that. File is closed. Therefore, I strongly believe in these cases, the family would be eligible for the funeral and burial expenses, and it fits the statute, and this regulations language contradicts that. So we'd really appreciate you visiting that again and thinking and making the necessary change. It is also a humanitarian thing, a program that's there to help crime victims. And we understand if you are limited by statute and you cannot pay, but when there is a way to really deeply think and find a way to help victims, then it's really necessary, and it's something that the program must do. On the proposed amendment of 649.7, a complete application, I suggest the specific supporting documents you are asking for when someone else other than victim signs or files on their behalf to be specified. For example, a power of attorney is an acceptable legal document in this case. When the language is vague, I think it leads to staff having different interpretation of what is an acceptable supporting document. So any other supporting documents that you think are acceptable to be included in the regulation language will prevent different interpretation by staff. On the proposed amendment of 649.8, 49.7, a complete application. We understand that if the attorney or the authorized representative is involved at the time the initial application is filed, of course, their name, contact information should be on the application. But oftentimes in our case, which we are one of very few advocates outside of the local victim assistance program that assist crime victims at no cost to them with victim compensation. And we get involved oftentimes when others have failed victims, when the local victim witness offices are not doing what they're supposed to, or CA VCB is giving victims the runaround, it's incorrectly denying claims. So our involvement is after the application is filed. And currently, the CA VCB has a forum where we fill out, or a language that authorizes and give consent by the applicant for us to represent them. And we submit that and it works. It would be putting a big burden on us and the victim to have to complete the application again, and it will cause confusion. I've seen applications submitted again where it's keyed in the system, creates a duplicate, it's inefficient, it's a lot of work on both your end and a burden on the process of the victims and us. So we really we don't want any confusion of that forum is to be incorporated, because the law gives us the authority to represent, and it says you are to put the guidelines on what, and so far what you have in place works fine. The proposed amendment on 649.7C, a copy of the crime report evidencing the commission of a qualifying crime. We're asking that you include other evidence of crime, not just the crime report, to really make it clear that there are other documents that can qualify the claim, including medical records, mental health records, court documents, restraining orders, not necessarily a crime report. It's mostly a crime report, but when that is lacking for legitimate reasons, those other documents should be listed so everyone knows to accept them and qualify the claim. And it is fine that applicants are encouraged to obtain and submit the crime documentation with their application if they're available. But I am afraid reading this language leads me to see that the program is shifting that burden more for the victims to obtain that, specifically the word that says if the applicant or the representative is unable to obtain the crime report or declines to do so. I don't understand why that word declines is in there. It gives the impression that the victim may be uncooperative, when victims applicants should have absolutely no burden while dealing with the trauma to have to go obtain a crime report. If they have it, submit it, great. But it's next to impossible to get crime reports from police departments, especially in the cases I work on, murder cases. It can take years. Victims would have to pay for it, when the local victim witness offices, as well as CA VCB, can get it at no cost, have the law, the powers, the resources to get it. And you are the agency required to verify the claim. Therefore, making it clear in there that the CAL VCB and its representative, and by the way, all victim witness offices, not necessarily the joint powers victim witness offices, which you have that language in there, those are the ones shall obtain the crime report when the victim can't. All victim witness offices have a grant, they're paid, and it's part of the contract's requirement to assist victims with CAL VCB application and obtain records. Mostly they're in DA offices. It's really easy. The language should be clear. They shall obtain these crime reports for CAL VCB to be able to make a decision, and also put a time limit. I'm afraid if open-ended, especially when the current regulation also specify that the application is not considered complete until crime documentation is there. We can understand you need that in order to make a decision, but there has to be a time limit requirement for staff to verify immediately. I've known of victim advocates who can sit on an application for weeks, not attempt at verifying. And that creates a problem for victims. There is a reason why the legislators have put a time requirement in processing the application. You must process in so many days. And if this is saying, regulations saying, oh, well, it's not complete until the crime report, but it is silent on when verification must happen, then it can sit there for months and it's still incomplete. Therefore, it creates a loophole for calculating the time. It just freezes the time that's required for processing. So please do think about that. These regulations become permanent records and can be used for many years, and the language, if not strong and clear to benefit the victims, then it creates these problems. On the proposed amendment of 649.24, reimbursement to service providers ineligible for reimbursement. I'm reading the three amendments, the sections 649.28, 24, and 649.50. I feel it's so heavy-handed on the providers of services, and it leads one to believe there is a widespread fraud by service providers, which really don't believe it. There will always be some people who will attempt at defrauding any programs, but especially in this program, it's not that common, not possible, because it's so difficult to maneuver this program. So it's so difficult to understand how it works. Many providers around the state of California don't want to deal with this program. The delays, the denials, the low amount of reimbursement doesn't allow for this. And to put such burdens, such heavy language on, they're not qualified, they would have to expect providers to understand or know the statutes or regulation of CAL VCB is so unreasonable. These are difficult information to even find out. I've gone to your website, and I just last night again, I was looking at how to find these statues, and it is hidden somewhere in a tab where if you maneuver, you wouldn't even find it. It's not easy for service providers, and there are so few of them out there who are willing to treat crime victims. It's not fair, and the program really needs to find a way to bring in more providers, make it easier, train them to make sure they understand and be able to serve. Victims do need that. So many are suffering out there and not able to find the right provider that can be reimbursed within the fees of the program. So I'm asking that you revisit that as well. And those are all the comments that I have. Thank you so much for the opportunity to comment. And at the last meeting, my college intern suggested, and we talked about, she and I talked about it, that these hearings be more of an engagement where there are questions and answers. It's really a good idea that she put in there, and I like it, and I hope in the future these public hearings can be really a conversation where we can answer your questions, so we can resolve some of these issues. I think we can do better if that's done. Thank you so much.